Okay, now we're going to be moving on to stage 2 of the process in civil litigation. And there's a lot of things that you're going to want to do once that client retains. And it's very important for us to make sure we've got things covered as it goes. But it all starts and maybe even kind of ends because it's so important with that case manager meeting. No matter what it is, especially in a civil litigation case, you want that case manager meeting. As soon as a client retains, that means the case manager on their own, but certainly by task if you need to, get that case manager meeting happening within 2 days of the retaining. They need to hear, I just paid a lot of money and I need to go forward with my case. The case manager will get to know the client, make sure all pleadings are complete, do a summons if necessary, get the client's exhibits and evidence, all of it, scan it and label it. It's so important that you scan information, label it, and hand it back to the client. We do not want originals. We want to have a robust filing system in our Clio system, but we do not want to be the one holding on to originals. You want to find out all the witnesses and you want to put them on Clio, prepare subpoenas if necessary for the case, and then collect all that homework from the client because you're really wanting to build that case up. That case manager meeting is so important. It's probably going to take an hour of time, but this is the first time the client needs to start hearing that, what this case is going to really look like and what kind of process will be involved in it. Next, you want to go through all of your list. You want to assign the list of tasks to the case manager. You need to think about what this is. If it's a construction case, you want to get all the old documents, you want to get the deeds, you want to get all those things, make a task and just keep putting the task and just dream it up. The more you think that you want and the more information that you want from the case manager, the more things that is going to go and get that process taken care of. And then you want to work on the opinion letter. So the opinion letter, as soon as that person retains, you're starting to working on that, and you want to do an introduction, thank that client for retaining, explain that the letter is going to give the client a full detailed assessment of the facts so they can be corrected as needed. So you're listing out the facts. Why? So the client can fix them. So later on, when the client says, well, that's not really the way things happen, you can say, don't you remember from the very beginning, I had an opinion letter. That's what you were supposed to tell me all of the important facts. You want to write those in third person. You want the law in every area of the case that they have. You want to get that from the bench book. You want to know what the jury instructions are on this particular kind of civil litigation. And you want to have any of the defenses that are expected in the case. And you want to have a conclusion that is to reduce the expectation of the client in that opinion letter. In civil litigation, it's so important that the client's expectation is accurate, and you want that detailed letter. It may be a 15, 16-page letter that you're sending out to the client. Pop it in the portal and maybe even sending it to them. But you also want to estimate the fees. You want to give them an idea about what kind of cost it's going to be. Now you've done the legal research and the factual research and what's going on. You want to go from that point forward into closing the case. Talk to the client, you as an attorney, and you want to remind yourself that we make money by opening cases and closing cases. So now that the case is open, everything you do should be focused on closing that case. The client may think that the case is close to settlement, but the more we push, the higher our bill is going to go, and the client's unhappiness is going to increase with time. You want to make sure you're negotiating quickly. You don't want months to drag by any stretch. You want to get the information back. You want to send it to the other side. You want to give them 7 days to come up with a resolution, then you want to file. You should be filing your case within 2 weeks of that client retaining our firm. There is no need for wait. Wait is only going to create problems for you. You need to be focused on these cases and moving them through as quickly as you can. The complaint itself will have an introduction explaining what we're doing, the jurisdictional points, and then the basic facts. You want to go back to that case manager meeting and all of the facts in the case, attach exhibits and evidence if you can into it, then put the claims in, list in order, and gives a very solid prayer for relief. Put a notice of hearing up as soon as possible. A lot of times cases resolve when you've got a judge involved. So you want to get it in early for pretrial purposes and those things. A lot of times the trial court administrator is going to be in charge of that, depending on what county you're in. So you want to talk to the trial court administrator, say, I'm filing this new case. I want to get in as quick as I can. Can you tell me how I can get a pretrial order drafted as soon as possible and get that scheduled? Subpoena witnesses. The only question you should have of whether you need to subpoena witness is, would I have this trial if the witness was here or not? If the answer is no, I wouldn't want to have this trial without this witness, then you need to subpoena them, even if you think that they'll probably come. And then have depositions. Depose the other side. Get that done as quick as you can. Don't take more than 2 hours on it, but your depositions should be quick, to the point, but do them. Do depositions of important key witnesses, and make sure that the client understands that this is an important part of getting the evidence you need to go forward in trial, because generally speaking, you're going to be using this going into a summary judgment. You want a pretrial order that gives the ideas of the date and time for trial, expected length, the facts that are stipulated by the party, all witnesses, all evidence, and evidentiary disputes that you're going to have. You want all of that in a pretrial order. And then put together your trial notebook. Case managers immediately address it. You want to have a good table of contents, a trial brief, a summary of the case, all of the pleadings, all the evidence, a consent order in case you can get this case settled, any witness interview sheets of any witnesses that will be coming up. Make sure you always have a copy of the local rules of court and the bench book for all claims relevant to the hearing. You always want to go back to that bench book, which will tell you what to have. And then when you have the trial, make sure that you have a good pretrial conference and talk to the judge before the case. Make sure you can explain your position within 5 minutes, because a lot of this discussion is going to be back and forth with the judge, and you're going to want to do that at that early stage. Make sure you know your objections, your hearsay, your relevance, and all of the objections that you might see. Make sure you have a plan to get every document admitted into evidence, including medical records and photographs. Text messages, email messages, they can come in. You got to authenticate them and show that they're coming from the other side. And then it's an admission of party opponent, and it comes in. And then always ask to draft the order when you win your case. Make sure you get all the parts in there. Make sure your order is very clearly stated, and that gets you what you want. So when you're going through your case, the best thing for you to do is constantly have your case reviews, talking to your case manager. Make sure that discussion is going on, and make sure you're splitting up those things in really good time entries for what we do. You can call me anytime with any questions about civil litigation cases. 828-289-1135 gets right to me. I love to talk civil litigation cases. Love to be able to chat my way through it. Look forward to talking to you a little bit more and understanding a little bit more about what we do here at King Law University. And I want to make sure that you're the top gun in that courtroom when you're in your civil cases. So good luck with it, and keep up that good work.